In the middle of a heated televised hearing of the House Judiciary Committee, Marjorie Taylor Greene, a skilled congresswoman accustomed to dominating every hearing, sat motionless in the chair. Jasmine Crockett suddenly stood up, holding a thick file in her hand. In front of dozens of reporters and millions of viewers watching, she pointed directly at Marjorie Taylor Greene and declared, "You cited a case that never actually existed." Not stopping there, Jasmine added, "Mr. Chairman, you have been wrong about the law all along, and I have the evidence to prove it." The next few minutes turned into a political earthquake. In less than a day, the video of this confrontation reached tens of millions of views, rocking the media and forcing Greene, who once lived on confidence in political theater, to face the biggest challenge of her career. So what was the truth that Jasmine Crockett revealed? Why did it become the most viral clip of the year? Watch until the end, because this story is worth every minute of your time. The hearing room was frozen. Cameras were set, mics were hot, and nobody moved. Marjorie Taylor Greene sat in the chair seat with her game day look. Crisp white blouse, bold yellow accent, posture straight, eyes steady. Across from her, Jasmine Crockett slid a thick folder onto the desk and didn't smile. Greene had the storyline ready. Weaponization of DOJ, tough questions, quick sound bites, and a clean run on cable hits tonight. Her team stacked binders, lined up graphics, and circled phrases built to trend. Producers had penciled her into prime time, 3 segments deep, expecting highlight reels by sunset. The script counted on force and speed, the kind that buries details under volume. What it didn't count on was someone who had done the slow work. Crockett wasn't here for the show. She was here for the statute, the holding, the rule. And when preparation meets a shaky script, the first thing to break is the confidence in the chair. Marjorie Taylor Greene had built her image on force. She wasn't a lawyer, she wasn't a judge, but she carried herself like the loudest voice in the room could win the argument. For years, she leaned into that style. Talk fast, talk big. Don't pause long enough for anyone to fact-check. She spoke about the Constitution with the same fire she used on campaign stages, treating it like a weapon to swing instead of a text to understand. Supporters loved it. Clips of her tearing into Democrats traveled fast online, always sharp, always personal, always delivered with absolute confidence. To many, she was the embodiment of raw political energy, unfiltered, unapologetic, and convinced that volume could substitute for legal training. Jasmine Crockett, by contrast, came in with a different set of tools. She wasn't new to confrontation. She had been a civil rights lawyer for more than a decade, standing in real courtrooms with real stakes. Judges cut her off, opposing counsel pressed her hard, but she learned to survive by knowing the law down to the comma. In Washington, she carried the same habit. For months, she had been quietly jotting down every time Greene twisted or flat out invented a precedent. She marked them in a notebook, case by case, statute by statute, building a record no one else bothered to keep. Crockett didn't need to shout. She prepared like someone whose client's futures had once depended on her precision, and that calm discipline was her edge. The stakes in this clash were bigger than either woman's ego. Greene had staged this hearing to frame the Justice Department as a political hit squad, weaponized against conservatives. If she landed her narrative cleanly, it would feed hours of primetime commentary, raise money, and rally her base. Conservative outlets had already banked on that outcome. But Crockett had come armed to show that Greene's narrative wasn't just spin. It was built on legal claims that cracked apart the second someone tested them. And if Crockett pulled it off, Greene wouldn't just lose a round, she'd lose the storyline that kept her powerful. That was the pressure hanging over every word about to be spoken. Marjorie Taylor Greene leaned into her mic, voice sharp, pacing steady, no notes in front of her. "Ladies and gentlemen," she began, "we are here to examine the greatest threat to our democracy today, the weaponization of our justice system." Her words came fast and heavy, like a prosecutor delivering a closing argument. She rolled through amendments like check marks on a list. The first, the fourth, the fifth, the 14th. To a casual ear, it sounded airtight. She quoted case names with confidence. dropped statute numbers like she had lived in law libraries. Every line was meant to land as fact. Every phrase delivered with the certainty of someone daring you to disagree. Reporters scribbled, cameras stayed locked on her. The performance had the feel of control. But while Greene rattled off her citations, Jasmine Crockett was busy. Her notebook was already open, pen moving quick, circling, underlining, jotting shorthand marks every time Greene bent a precedent or shaved a statute into a soundbite. Crockett's eyes didn't leave the page, and her pen didn't stop. To her, this wasn't a speech. It was evidence being handed over in real time. She knew which cases said the opposite of what Greene claimed. She knew which statutes Greene left half-quoted. Line after line, her notes grew into a record, the kind that could flip the energy of the room once her turn came. Then something new lit up. Behind the committee dais, a large screen had been set to display supporting text. Staffers, maybe trying to be helpful, began pulling the actual language of the laws Greene cited onto the display. At first, it looked like a visual aid, but the longer Greene spoke, the more obvious the gaps became. She'd say one thing, and a beat later, the screen would flash the real text. Different words, missing phrases, contradictions in plain sight. Reporters looked up from their notepads. Phones lifted to record. A low murmur moved across the gallery as people realized the disconnect wasn't subtle. It was glaring. Greene kept going, unaware the screen was turning her certainty into liability. And Crockett, still scribbling, knew the foundation was already cracking before she even asked her first question. Crockett leaned forward, adjusting the microphone until the squeak of feedback faded and the room went quiet again. Her voice came out calm, steady, but with the sharp edge of someone who had studied every angle. "Madam Chair," she began, locking eyes with Marjorie Taylor Greene, "you cited Brandenburg versus Ohio in your opening statement. Do you recall what year that case was decided?" Greene gave a quick smirk, as if the question was beneath her. 1969, she replied, sharp and dismissive, like she had been waiting to prove she knew at least that much. A few reporters nodded, scribbling notes. "Correct," Crockett said evenly, flipping a tab in her binder. "And the holding?" Greene leaned back in her chair and rattled off her version with confidence. "The court ruled that inflammatory speech is protected unless it incites imminent lawless action." She delivered it like a rehearsed line, but Crockett tapped her pen on the folder twice, waiting until the tension thickened. "Almost," she said, "but not quite." Crockett leaned closer to the mic and read slowly from the case itself. "Speech is protected unless it is directed to inciting or producing imminent lawless action and is likely to incite or produce such action." The word "likely" landed like a hammer in the silent room. Behind Greene, the big screen lit up with the official language, the missing phrase highlighted in yellow for everyone to see. Reporters snapped their heads up, fingers flying across phones and keyboards. Crockett's tone hardened. "You left out the likelihood requirement, Madam Chair." "That's not a small detail. That's the difference between what is protected speech and what is a crime. So tell me, why did you leave it out?" Greene shifted, her jaw tight, and muttered, "Splitting hairs." Crockett shot back instantly. "Splitting hairs is debating punctuation. This is the core of the test, and you twisted it. The American people deserve to know the actual law, not a cut-down version that fits your narrative." Before Greene could form a reply, Crockett flipped to another tab and held up a printout. "Next, 18 U.S.C. Section 1512C. You claimed it requires the physical destruction of evidence. Let's read it together." Her voice was calm, but the challenge was clear. "Whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined or imprisoned not more than 20 years, or both." She lowered the paper slowly. "Where in this statute does it say anything about shredding evidence? Where does it say physical destruction is required?" Greene tugged at her sleeve and snapped, "That's how courts have interpreted it." Crockett didn't miss a beat. "Name one case," she demanded. "Just one." She paused long enough for silence to swallow the room. "I've checked them all, and not one agrees with your claim." The screen behind them flashed the full text of the statute, the words "official proceeding" glowing in bold. Reporters' eyes widened. Greene's counsel leaned in frantically, whispering, But Greene's face froze. Her lips pressed shut. Crockett marked another sharp tick in her notebook and moved on without waiting. And finally, Crockett said, her tone steady but heavier now, United States versus Nixon. You used it to argue that executive privilege is absolute. She opened her binder again. Here is what the court actually said. Neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communications, without more, can sustain an absolute, unqualified presidential privilege. The words rolled onto the screen behind them, highlighted in blue, undeniable. Crockett raised her head. That's the court saying privilege is not absolute. That's the case that forced Nixon to hand over the Watergate tapes. You cited it for the exact opposite point. Why? Greene slammed her palm against the desk, her voice rising. You're twisting it. That's not what I said. But as she leaned back toward her aide, the microphones caught her whisper clear as day. Push it to free speech. Pivot the angle. Gasps shot through the gallery. Reporters looked at one another in disbelief as the hot mic moment replayed in their minds. Crockett tilted her head slightly, almost smiling, then spoke into the mic. For the record, the chair has just instructed her staff to pivot arguments after being challenged on precedent. That's not how law works. You don't pivot out of case law, you face it. The silence in the room was electric, as if everyone knew the ground had shifted. Greene's knuckles tightened around her mic. Her face flushed red. But Crockett was already turning to the next tab, calm and methodical, while the weight of the moment pressed down on every person in the chamber. Crockett didn't rush. She turned another tab, and when she spoke, her voice carried a deliberate patience that only made the tension worse. Madam Chair, you've claimed repeatedly that the FBI trampled on the Fourth Amendment by using geofence warrants. You've said, and I quote, these were illegal dragnets. She paused, letting the phrase hang like smoke in the air. Then she leaned in. Tell me, are you familiar with Carpenter versus United States? Greene straightened in her chair, her chin tilted high. Of course I am, she said with irritation. Everyone on this committee knows Carpenter. She expected that line to be enough, but Crockett didn't blink. Then you know Carpenter set the standard. It required warrants for cell phone location data, and the FBI got those warrants. She flipped open her folder and raised a document so the cameras could catch the header. Eastern District of Virginia, United States versus Chattree. In Chattree, the court upheld geofence warrants with specific limitations. In Rhine, upheld. In the Google search case, upheld. As she named each case, the screen behind the dais lit up with the rulings, their key lines highlighted. These weren't rogue actions. These were warrants reviewed and approved by judges, Republican-appointed judges. So tell us, Madam Chair, what legal precedent are you using to say they were unconstitutional? The room held still. Greene rifled through her notes, flipping pages she hadn't memorized. Her counsel leaned close, whispering in her ear, but her mic caught just enough to broadcast. Say overbroad. Greene stiffened and repeated it. The warrants were overbroad, Crockett pounced. Overbroad? Based on what authority? Which case says these geofence warrants failed constitutional standards? Because I've researched this extensively, and every court has upheld them when properly limited. Name. 1. Case. She stabbed her finger toward Greene, her voice no longer calm but cutting. Greene opened her mouth, then closed it. Nothing came. The reporters saw it, the cameras saw it, and the crowd in the gallery started murmuring like a storm was breaking. Crockett didn't give her space to breathe. She flipped another tab. Now let's discuss Thompson versus Louisiana. You cited it in your subpoena letter to claim warrantless searches are categorically unconstitutional. There's only one problem. She paused long enough for the silence to choke the room. That case does not exist. The effect was immediate. A gasp cut through the gallery, followed by the frantic tapping of phone screens. Reporters leaned forward as if to make sure they'd heard her correctly. There is Thompson versus Louisiana from 1984, about crime scene searches, Crockett continued, and Louisiana versus Thompson from 1990, about jury instructions, but there is no Supreme Court case called Thompson versus Louisiana that says what you claim. None. She reached for a thick black casebook and dropped it on the desk with a thud so loud it echoed through the chamber. I searched Westlaw. I searched Lexis. I searched the Supreme Court's database. Nothing. You made it up for a full 3 seconds. You could have heard a pin drop. Greene's face turned crimson. Her lips pressed together so tightly it looked like she might crack a tooth. Her staffers looked down at their papers, pretending to be busy, avoiding every camera pointed their way. And just when the air couldn't get heavier, Crockett reached into her folder again and pulled out a sealed envelope marked Exhibit X. She slid it toward the clerk, her eyes never leaving Greene's. For the record, this is an internal memo from your own staff, entered into evidence this morning. The clerk stamped it, and the camera operator zoomed in. Crockett kept going, her voice crisp. This memo, your memo, admits that several citations in your subpoena letter had not been verified before you signed it. In other words, you were warned. You knew the citations weren't checked, and you pushed it through anyway. The gallery erupted in whispers, and reporters whipped their heads back and forth, trying to catch Greene's reaction. Greene leaned toward her aide, her voice raised this time, not realizing her mic was still live. Who leaked that? Who gave her that memo? The whole room heard it. Reporters' jaws dropped. Fingers clattered on keyboards. Crockett didn't miss a beat. She pointed straight at Greene. So it's not about whether the memo exists. You just confirmed it does. You want to know who gave it to me? Try looking in your own office, because apparently even your staff doesn't trust you to get the law right. Gas swept the room again, louder than before. Greene slammed her hand on the desk, her face flushed red, trying to regain control. This is a setup. This is political theater, she shouted. No, Crockett fired back, her voice steady but sharp enough to cut glass. This is accountability. This is what happens when the chair of the Judiciary Committee signs her name to legal citations she knows haven't been verified. That's not oversight. That's negligence. And negligence from this seat isn't just sloppy, it's dangerous. The hearing room shook with tension. Some members on Greene's side stared down at their papers, refusing to meet her eye. On the other side, Democrats bit their lips to hide smiles. The story was already writing itself in real time. Greene's phantom case, her staff memo, her credibility cracking under the weight of facts. And Jasmine Crockett wasn't done yet. When the gavel came down for a 5-minute recess, everyone in the room knew it wasn't about bathrooms. Greene's staff huddled around her like a football team at halftime, sliding talking points across the table, whispering frantically, pointing at highlighted pages. She nodded hard, her jaw tight, flipping through the new stack of notes they shoved into her hands. Cameras caught her lips moving silently, rehearsing lines. By the time she strode back in, she looked rehearsed, armored, and determined to regain control. She tapped her microphone once, her eyes darting toward Crockett with barely concealed fury. The stage was set for round 2. Crockett wasted no time. Madam Chair, she began, her tone crisp, you claimed earlier that the Due Process Clause of the 14th Amendment guarantees every federal defendant a jury trial. She opened her folder. That is not true. The Supreme Court has held in Lewis versus United States and District of Columbia versus Clancy that petty offenses carrying a maximum of 6 months do not require jury trials. She paused, letting that land. 40% of January 6th defendants are facing misdemeanor charges with maximum 6-month sentences, parading, demonstrating, or picketing in the Capitol. Under controlling precedent, no jury trial required. The big screen lit up again, showing the word misdemeanor with a bold 6-month cap underlined. Greene leaned into her mic. I was speaking generally about the serious charges. Crockett cut her off, her voice sharper now. So you admit you misled the public when you said every defendant was denied a jury trial? Madam Chair, this isn't semantics. This is the Constitution, and you twisted it. The gallery erupted in murmurs as reporters scrambled to get the quote down. Greene tried a different move. She raised her hand abruptly and spoke in her official tone. Point of order. The gentlewoman's time is for questioning the witness, not cross-examining the chair. She banged the gavel once, trying to cut Crockett off. The room buzzed as members leaned forward, sensing a procedural fight. For a moment, it looked like Greene had won back control, but then the committee's counsel, a seasoned, gray-haired lawyer sitting at the end of the dais, leaned into his mic for the record. "Madam Chair," he said carefully, "the line of questioning goes to the foundation of the chair's own legal claims, which were cited in official letters. That makes it relevant and permissible." The words landed like a hammer. Gasps broke out across the room as Greene's attempt to shut it down backfired. The gavel hung awkwardly in her hand. "The chair rules the gentlewoman may proceed," the counsel finished. Even some Republican members muttered under their breath. The reversal was public, humiliating, and undeniable. Crockett seized the moment. "Thank you," she said, her eyes locked on Greene. She lifted another page, this one from the American Bar Association's Rules of Professional Conduct. Rule 8.4, Misconduct. It is professional misconduct for a lawyer to engage in dishonesty, fraud, deceit, or misrepresentation. She let the words roll slowly, each one heavy. "Now, Madam Chair, you may not be a practicing attorney, but if you were, your repeated misstatements of law, false cases, incorrect statutes, misleading precedents would be grounds for disciplinary action. Any real lawyer who did what you've done in this committee would be sanctioned or disbarred." Greene tried to laugh it off, but the sound fell flat. A nervous bark swallowed quickly. The cameras caught her hand trembling slightly as she gripped the edge of the table. Then came the final blow. Crockett slid another folder across the table, stamped and ready. "For the record, I will be filing a formal notice of correction. This document lists 43 false or misleading statements of law you've made in your official capacity, 16 statutes you misquoted, 9 cases you cited incorrectly, and 1 completely fabricated case. This notice will be entered publicly with a deadline for you to respond. The American people deserve to know the truth." The words hit like an indictment. Reporters' fingers clattered against keyboards. Members leaned forward, whispering furiously to staff. Greene's eyes darted to the cameras, then back to Crockett, then down to the folder as though it were radioactive. The room was electric. What was supposed to be Greene's show had flipped into a slow-motion wreck, her authority crumbling in front of a national audience. And Crockett, methodical and relentless, had turned parliamentary chess into checkmate. Adam Schiff leaned into his mic, voice cool but firm. "Mr. Clerk, I move that all of Representative Crockett's documentation be entered into the official record." Jerry Nadler immediately seconded. That was expected. What wasn't expected were the 2 Republican hands that went up moments later, Ken Buck and Nancy Mace. Their decision stunned the room. For weeks, they had kept their distance from Crockett's crusade, but now with Greene's credibility in freefall, they broke ranks. The vote wasn't even close. Greene had no choice but to mutter through clenched teeth, "Without objection, so ordered." The clerk stamped the binder, and just like that, every mistake, every false case, every shaky claim was locked into history. The gallery broke into chaos. Reporters leapt from their seats, phones raised, running for the exits to blast the news first. Staffers whispered in frantic huddles, scribbling updates for their bosses. 2 aides nearly collided trying to rush papers to their members. The noise swelled until the sergeant-at-arms stood and barked, "Order! The chamber will come to order." His voice echoed like a drill sergeant, pulling the chaos back into a tense silence. Greene banged the gavel, her face flushed, her knuckles white, but the image was already burned into every camera angle, control slipping from her hands. Then Crockett struck with her final pivot. She leaned forward, her tone steady but sharper than ever. "Madam Chair, you have spent months telling the country you were protecting January 6 defendants. But here's the truth. By giving them false hope in bad law, you may have done them harm." She lifted a transcript of Greene's TV appearance, the quote highlighted in yellow. "Every single January 6 defendant is being denied a jury trial. That's what you said. Yet 40% are facing petty offenses where no jury is required. Your words misled them about their rights." Crockett's gaze was unblinking. "So my question is simple. Will you apologize? Not to me, not to this committee, but to those defendants and their families, because they made choices based on your words, and your words were wrong." The room went deathly still. Reporters froze mid-type. Even Greene's own allies stared at her, waiting. If she admitted she was wrong, she destroyed her narrative. If she doubled down, Crockett had the receipts to bury her deeper. Greene sputtered, I was speaking generally about the serious cases. So you admit you exaggerated constitutional rights for political gain? Crockett cut in, her tone like a blade. Greene's face burned red, her mouth opening and closing with no clear defense. The silence that followed was brutal. Before Greene could regain footing, Schiff seized the momentum. Mr. Chairman, I move for a show of hands in support of a resolution, in principle, requiring continuing legal education for judiciary members. Nadler seconded instantly. Hands shot up across the Democratic side. But what turned heads was the handful of Republicans who raised theirs too, more than anyone expected. It wasn't binding yet, but the signal was clear. The tide had shifted. The committee itself had delivered its verdict. Greene's legal theater had collapsed into an ethics lesson, and the lesson was written in bold ink for the entire country to see. Within hours, the clip exploded. News anchors replayed the exchange on loop, cutting between Crockett's calm precision and Greene's stumbles. CNN broke into programming mid-segment to air highlights. Even Fox News, scrambling to spin, couldn't avoid showing the hot mic moment. Legal analysts called it the most devastating fact check ever caught on camera. Law professors at Harvard and Yale announced they would use the video in their constitutional law courses. The American Bar Association released a statement praising the exchange as a vital reminder of the importance of accuracy in legal discourse. Across social media, hashtags like #ReceiptsMatter and #CrockettCheck trended for days. The moment had crossed from politics into culture, but it didn't stop there. The fallout turned into something larger. The House Judiciary Committee, rocked by the embarrassment, adopted a new rule. Every hearing involving constitutional claims would now have nonpartisan legal counsel present, fact-checking statements in real time. Alongside it came a mandatory requirement. All members of the committee must complete 4 hours of continuing legal education every month. It wasn't just an informal lesson anymore. It was procedure written into the record. This wasn't a fad. It was the Crockett standard. Outside Congress, pressure built for transparency. Within weeks, a public-facing legal accuracy dashboard went live. Every time a member of Congress cited a case, statute, or constitutional principle, staff logged it, reviewed it, and marked it. True, false, or under review. Citizens could see for themselves who was speaking from fact and who was bluffing. Late-night comedians turned the dashboard into punchlines, while civic groups hailed it as a revolution in accountability. For the first time, voters didn't have to guess. They could track legal truth the same way they track votes. Months later, standing before a packed lecture hall, Crockett summed up the meaning of it all in one line. "The law isn't a prop," she said. "It's a promise. And that promise only works if we respect the truth." Her words echoed far beyond the classroom. They became a challenge to politicians, lawyers, and citizens alike. Accuracy isn't optional. Truth doesn't defend itself. It needs defenders. And that, more than the viral clip or the headlines, was the real legacy. The day Greene lost control wasn't remembered just as her downfall. It was remembered as the moment the ground rules changed. When the standards shifted from who could shout the loudest to who could prove the facts. If you enjoyed this story, don't forget to like the video, share it with your friends, and subscribe to the channel for more powerful stories that bring truth, drama, and lessons to life. Your support helps us keep creating content that matters. This story is 100% fictional and created purely for entertainment purposes. It does not depict real events, nor does it represent the actions, beliefs, or words of any real individuals. Any resemblance to actual persons, living or dead, or real events is purely coincidental. The characters mentioned in this story, such as Marjorie Taylor Greene, Jasmine Crockett, Adam Schiff, Jerry Nadler, and others, are fictionalized figures used only within the context of this creative narrative. They are not the real people who share those names.